Hi, everyone. We're going to get started. We have quite a few people joining us today, so I want to make sure we have plenty of time for any questions you may have. So thanks for joining us. I'm Sharon Campo. I'm a supervising attorney here at Legal Services of Long Island, formerly known as NASA Suffolk Law Services. And thanks so much for joining us today. We have a presentation on emergency housing assistance on Long Island. So let me just go through the beginning slides, introduce everything and us. So for those of you who are unfamiliar, we were formerly NASA Suffolk Law Services. In September, we changed our name to Legal Services of Long Island. We're the same organization, just a different name that represents better who we are and what we do and who we represent. Our services are still free, and we still provide civil legal services all throughout Long Island. So just a little bit of housekeeping, just make sure to keep your microphone muted so that way there's no background noise and everyone can hear each other. If you do have questions, feel free to put them into the chat and we will address them at the end of the presentation. You may find that some of your questions are addressed throughout the presentation. So I would suggest maybe just writing them down. And then if it's not addressed, you can put it into the chat towards the end of the presentation. And John and Jacob will address your questions. However, if we get close to 2 o'clock or we're starting to go over 2 o'clock, they may just tell you that they can address the questions later on via email because we don't want to keep anybody. We'll have a few polls throughout the presentation. And I'm going to ask, we do have a survey at the end. So if you don't mind filling out the survey, I'd really appreciate it. So if you're unfamiliar with Legal Services of Long Island, we are Long Island's largest civil legal services organization on Long Island. We handle over 6,000 legal cases every year. All of our services are free for eligible Long Island residents. We handle direct representation, phone consultations. We make it free service over the phone or give out referrals to other organizations as appropriate. We have offices in Hempstead, Islandia, and Riverhead. And we do have staff, including attorneys, paralegals, social workers, and we have partnerships with community agencies as well, such as Empire Justice or Brighter Tomorrows and other organizations. So these are the offices of that we have in Hempstead, Islandia, and Riverhead, and their phone numbers. If you are a client or if you have a client who is seeking legal services, please have them call this phone number so they can be screened for services. We have about 21 now, actually, different programs. We just added a few more, but we have Domestic Violence Project in Suffolk County, our Child Support Defense Project in Suffolk County. We have a variety of disability and health-related units, including Disability Advocacy Project and the Education Disability Rights Project. Any of the descriptions of the different units are on our website, so feel free to take a look to see what specifically these units handle. We have Civil Unit, which is our housing unit, eviction prevention, foreclosure project. We have other different units, including consumer debt, Veterans Rights Project, public benefits. We just added a new project the last few weeks, which is the Naturalization and Citizenship Project, which will be assisting permanent residents in applying for citizenship. So that is a new project that we just added. And our Legal Support Center for Advocates. This is a program that's specifically for advocates only, including nonprofits, social workers, government agencies, different entities that may have a client who's having a problem, a legal problem. And if you have a question about whether or not it's a service we would provide, you can give us a call. Or if you just have a simple legal question, we can try to guide you through that. So once again, this is for advocates only. It's not for clients. Sometimes advocates give out clients' phone numbers or our phone number to clients. And unfortunately, we're not case handlers, and it's going to take a much longer time for your client to get the services needed if you have them call us. Clients do need to call the front desk so they can be screened, and that's the fastest way to get them services. So just keep that in mind. We do host community training, such as what we're doing today. We have newsletters that we send out via email or advocacy tips, and as well as print newsletters. So that is the Legal Support Center for Advocates. So really quick, just two quick polls. so we can get an idea of who's with us here today. So the first poll will be, what type of advocate are you? So let me just bring that up. And if you could take a moment just to answer the question, we'd really appreciate it. Okay, so we're at 92%. Just a few more people are answering the question. All right, so I'm going to end the poll and share the results. So today with us, we have a bunch of social workers, attorneys, nonprofit employees, church volunteers, and a handful of other folks. So thanks so much for joining us today. Really appreciate you being with us. We have 118 people here today, so that's awesome. So the next question is, have you ever called the Legal Support Center for Advocates? So I'm just going to launch that really quick. And if you could just answer that, really appreciate it. Okay, thanks so much for answering. Let's see what we got here. So it sounds like a bunch of you, so this is the first time you've heard about the Legal Support Center for Advocates. So welcome, and we hope you're able to use our service. And then we have also a bunch who have heard about it before, so welcome back. Okay, so let's continue on. So definitely check out our website. We have all of our legal lessons on there, which is our advocacy tips. Any of our past trainings are also on there. We have self-help resources, and of course, all about our programs. And just a reminder that we, of course, make every best effort to keep our educational materials up to date. Any information that you learned today is that's what it is. It's information. It's not legal advice. Legal advice does depend upon the specific facts of each situation, and the materials that we provide you today cannot replace the advice of competent legal counsel. Just keep that in mind. Okay, so with that, I'm going to pass it off to Jacob and John. And just let me know, just say next when you need me to go to the next slide, okay?
Great. Thank you very much, Sharon. Very nice to be with everyone here, and thank you for all attending. It's nice to see some familiar faces and names. So you can go, yeah, the next slide. So today's presentation, we're going to be talking about emergency housing, primarily with DSS. Our goal today is to explain how someone can apply for emergency housing, how DSS determines eligibility, if a person requires an accommodation with a policy that DSS has, explain how you can achieve that, some of the allowances a homeless client that's being provided services by DSS can obtain, and if a client is denied by DSS, how to fight that denial at a fair hearing. So the basic information on DSS is the Nassau and the Suffolk County offices are open from 8 a.m. to 4 p.m. Ideally, a homeless client should try to get to DSS by 12 o'clock to apply for emergency housing, because usually sometime after that, it becomes harder for them to be able to go through all the process and get placed if they're eligible. If it is after 4 or it's later in the day, they can also call the after hours service. And I have the number for both Nassau and Suffolk County, which are open generally from close of the business day to 8 a.m. the next day, as well as holidays and weekends. Next slide. So a client can apply for emergency housing by themselves or through a designated representative. It has to be in writing, signed and submitted at the time of regular business hours, either in person or by mail. The client would fill out the statewide form for all applications with DSS, which is LDSS-2921. Client would check off the box in section 1 for emergency assistance. And then in section 5, they can specify specifically all the particular um, issues they may be dealing with. So there's a spot for no place to stay, homeless, but they could also report that they have no food, they need childcare. There are also is a section about if someone is pregnant, they can check that box off, or if they're a victim of domestic violence. They also can check off if there's problems with English or reasonable accommodations. So there's a lot of things there that once those are checked off, then DSS should be aware or at least put it in through their process to question them about all those things. The interview for emergency housing should be the same day or as soon as necessary. The client should bring any relevant documents to demonstrate there is an emergency. So if they've been evicted by the sheriff's office, they should bring the 14-day notice showing that the time period for the 14 days has expired. If they've gotten anything from the sheriff when the eviction occurred, they can provide that. Anything that will make it easier for DSS to get to the right answer, hopefully, for the client. If there's income, they'll have to, document the income. If other household members have income, but they're not, that income is not available to meet the emergency, that should be specified in the application. They also should specify any special circumstances. And if they are denied, there should be a written denial notice that same day. And when a client if they qualify for emergency housing, clients should be aware that their income, their non-PA income, is also will be factored into calculating what their shelter share will be. Next slide. So right now, people should be aware that there is a regulation that allows for DSS to relax its policies. It's known as Code Blue. So it's triggered when the temperature drops to 32 degrees or below, which includes wind chill between 4 p.m. to 8 a.m. The policies that DSS relaxes in these times are the drop-in centers are required to take as many clients as possible within their occupancy restrictions. Single adult or family shelters are not required to undergo typical intake eligibility procedures for that night. Clients can access any shelter for that night. A shelter suspension or sanction will not bar a client from placement for that night. And these are the numbers for the hotlines, both in Nassau and Suffolk County. Next slide. DSS must investigate and determine if the applicant has available housing. If an available housing is defined as when it is within the control or ability of the applicant to live at the residence, or when the applicant has permission from the party responsible to live there. They have to have clear and convincing and credible evidence that the housing is not available. And DSS will investigate they can send field investigators or conduct interviews with the landlord or whoever was previously that the applicant was residing with to determine whether they actually have available housing or not. If they've determined that there's available housing, they'll deny the application. But if they've determined that there is no available housing, they'll move on to the next criteria for eligibility. Next slide. So a housing resource that's not available. So these are just some examples. Uh, requires a primary tenant or leaseholder to seek permission from a lessor for the residency, and such permission has been rejected or would not be granted. And the lack of a request does not make the housing resource unavailable. Another example would be when the applicant's residence would violate the lease or would be considered illegal, even if the applicant previously resided there. So a situation like that would be where an applicant previously resided at a family member's apartment that is it's a public housing or Section 8, where there's strict requirements on who's allowed to be there and for certain periods of time. And if the applicant were to continue to reside there, the family member could lose their or put at risk their voucher or their residency at the public housing. So that would be an example of where if it's documented how housing resource would not be available. Next slide. So the person that's taking the applicant in previously can provide a reasonable justification for DSS why the housing would not be available. And basically the DSS looks at it from a totality of the factors, which is the relationship of the primary tenant to the applicant, the length of the stay at the residence, the reason for declining permission to return, and any potential hardships in permitting the applicant to return to the residence. Next slide. Once DSS has determined that there is no available housing resource, they'll next look to see if there's available resources that the individual has that will qualify them to not be housed by DSS and be able to use those resources to prevent their being homeless. This is contrary to other programs that DSS runs, such as public assistance program, where clients are allowed to have a certain amount of resources or assets to be able to still qualify for a PA. But in emergency situations like emergency housing, client actually has to spend down their resource to and then prove that spend down to DSS to be able to qualify for emergency housing. So that is, again, resources that would otherwise be exempt for TA eligibility must be used to meet the cost of temporary housing. So DSS will require an applicant to spend down that money. And then an applicant must use any benefits, resources, or income to reduce or eliminate the needs for temporary housing. And so if DSS is aware of it and deny them because they have available resources, the next time the client comes in, they'll have to provide proof that they actually spent that money down. And this becomes trickier when a client has just received their SSI or SSD benefit for that month. And so that beginning of that month, they'll have to show how they spent that money down to be able to qualify for emergency housing. Next slide. And then again, there also will be, they'll determine what is the available income of the applicant. So whether the applicant's income is earned or unearned, it'll be budgeted to determine their shelter share. And DSS must inform the applicant in writing the monthly amount of their shelter share, as well as how and where to make the payments. And DSS uses the actual cost of the temporary housing rather than the maximum shelter standard under the standard of need criteria. So most times the shelter share the client has when there's any type of income is usually a very high amount. It's usually somewhere around 80% of their income. So it's a very large amount. And a lot of times we get a lot of calls up from clients trying to figure out if that's even correct or if there's a miscalculation. But it is unfortunately a large amount. Next slide. Now, a client can refuse a placement if DSS determines that they are eligible. They can refuse a placement as long as it's a reasonable refusal. So a reasonable refusal would include a verified medical condition, which would prevent them from being housed at that location, or the remoteness of the housing in relation to a medical service, or the distance it is for our employment when it's not accessible by public transportation, something along those lines would be considered a reasonable refusal to be placed at either a shelter location or a motel location. Next slide. Okay, and now Jacob will take over the remaining portion of today's training.
Hi, everybody. It's good to see so many folks here. So we're going to keep going here. So the Office of Temporary Disability Assistance requires the Department of Social Services to assess clients at various points. First, they are obviously required to assess whether they meet the criteria to get temporary housing assistance from before they are issued housing. And they are also required to assess clients before their housing is discontinued. Essentially, they need to make sure that there is no mental or physical impairment that would endanger the client if they have their housing turned off, essentially. They also need to evaluate if there are any external services that may be needed for the client. That includes, APS, if the adult service needs to be involved, or if some kind of preventative or protective care for children needs to get involved. And they also need to see if the client has any disabilities. This can be either if the client reports it themselves, or if it is observable. When generally they're much more likely to observe a disability or an impairment if it's a physical one, as opposed to make some kind of judgment as to somebody's mental state, except in the most extreme cases. And they do need to make a note of whether or not there is a disability. Now, and this is very important, when they make their initial evaluations to determine if a person can be housed, a written notice needs to be given the same day. So a lot of times what social services does and what they should do are not the same, and clients will often come in saying they were denied without this notice. So if a client comes to you before their initial journey to social services, it's very important to make sure they are aware that they are entitled to a notice the very same day, because that could create issues down the line of a fair hearing needs to be called. And we can go to the next slide. All right, and this is why social services needs to evaluate for disabilities. So the Americans with Disability Act protects individuals with disabilities. It says in the name. If a caseworker knows or suspects a client has a disability, that will make it difficult to comply with the DSS rule. The caseworker has to do a few things. They need to note the disability in the client's file so that other people working at the agency are aware of the disability. They need to offer the client a reasonable accommodation, even if the client has not requested it or disclosed their disability. Again, in my experience, they don't offer up accommodations without it being requested, except in the most extreme cases. They need to grant a reasonable accommodation if the client is asked for it. And they need to note in the file what kind of accommodation is given. Generally, in the emergency housing context, this often is something like a hotel or a motel if the client has some kind of mental impairment or mental disability that will make it difficult for them to be in a communal space. Some clients have a hard time, bending, getting up and down, so they'll want them to be on the bottom bunk if there are bunk beds in a shelter, things like that. Next slide. Thank you. And this is just getting more into the mechanics of how the ADA works. Under the ADA, providers need to make reasonable accommodations and rules, policies, practices, or services. When an accommodation is necessary to afford a person with a disability equal access to services, programs, or activities. So as I mentioned before, if a person's disability would prevent them from being able to use the shelter being provided to them, obviously they're not having equal access to the service. So the example I gave earlier, a placement at a hotel instead of a shelter due to a mental disability or allowing an emotional support animal when there is a no pets policy. That one in particular, I've noticed recently, social services, at least in Nassau, has been a little strange about. So make sure that a client has documentation that their animal is an emotional support animal or a therapy animal before they go to social services. Next slide, please. Thank you. And so here's some requirements for how this will go. First, the client will need to provide a letter from a medical professional supporting the request. As we stated before, there are times where social services can sort of waive that requirement if it's an obvious disability. The person's disability needs to be covered by law. The requested accommodation needs to be necessary to afford the person the equal opportunity to use and enjoy the dwelling and the related services. Again, like I mentioned earlier, there needs to be a connection between the requested accommodation and the person's disability. So, for example, if a person's disability is that they need to be in a room alone, DSS can't tell them they have to have a roommate. Now they don't always need to grant an accommodation. If it is unduly burdensome, meaning it's very financially or administratively straining for the agency, they don't need to grant that accommodation. Now, just to circle back, I want to talk a little bit more about the medical letters, because I've found that if a client goes to their doctor and just says they need a doctor's note, they tend to not be of the type that would be the most useful to get an accommodation request granted. So the format I like to use is I will tell the client to have the doctor say, number one, how long they've been treating them. Number two, what the condition is. Number three, what kind of things the condition makes it difficult to do. So, being in crowds, bending, just being on your feet for a long period of time. And then number four, explaining why that means they need whatever accommodation we're asking for. So why it means they need a single occupancy room, or why it means they need to be in a place where there's minimal stairs, things like that. Next slide, please. Now we're going to talk a little bit about some of the allowances that people get. So there are certain situations people may find themselves in that will allow them to get extra money, essentially, from the Department of Social Services. These allowances do get wrapped into any other cash assistance a client is getting. I only mention that because I've had clients call and get confused about why it is that they only got one lump of money when it says they're getting money for, public assistance and something else. Right. So in this case, first thing is a restaurant allowance. Pretty simple. It needs to be provided if housing doesn't include a fully equipped kitchen, and less than 3 days of meals are provided. Some shelters will provide meals, but for those that don't, this is the type of thing that people will get. It's important to note that if there's just a microwave, that's not a fully equipped kitchen. Generally, I haven't seen there be much of a problem with people getting the restaurant allowance when they need it, mostly because it's, they'll know based on whatever shelter or hotel they're being sent to if they have the kitchen or not. Next one is the pregnancy allowance. The pregnancy allowance and the restaurant allowance restaurant allowance generally ends up being $64 if there's 3 meals worth. If no meals are being provided, if they need all 3 meals worth. But it does change depending on if it's an individual or a family. And if you Google OTDA temporary assistance sourcebook, there'll be several pages with charts telling you how those calculations work. Same thing with the pregnancy allowance. This is an allowance if an individual is pregnant. The allowance kicks in at the start of the fourth month of pregnancy, or when DSS is first notified the person is pregnant, whichever is later. So if you have a client who's 4 months pregnant, you want to make sure they tell DSS sooner rather than later, because if they wait 2 months, they're not going to get the money. They're not going to get retro money. And that amount is usually $50. And then finally, we have the EAF allowance. This is essentially if a person is at risk of homelessness or is currently homeless, they will add an extra amount of money for childcare if necessary, or to travel around to look for housing and sometimes look for employment. And this amount varies pretty wildly depending on the person's individual circumstances. We can go to the next slide, please. All right, and then just a few more allowances. Storage allowance. Essentially, while a person is being housed by DSS, they are entitled to have a storage unit. DSS is supposed to use the most cost-effective storage options possible, but if a client was evicted and has their things in a storage unit, DSS, at least in my experience in Nassau, doesn't tend to make them move their belongings to a different place to reduce costs. the client has the option to accept an allowance to get furniture and other belongings once they find permanent housing instead of paying for storage. It is important to note that is an option. DSS cannot compel a client to do this instead of having their things kept in storage. And finally, there is a clothing and furniture replacement grant. This is not a, repeating payment the way these other programs are. But essentially, in the event of certain emergencies, DSS can grant money to people to replace clothing and furniture. It's important to note that especially for the furniture replacements, DSS will issue an amount of money based on the things replaced, based on a chart they have, again, in the source book. That will indicate, a bedroom set is $134, things like that. And they do tend to be lower than the reality of the situation. So often, if a client is going to be looking for a furniture voucher, it may be worthwhile to also look at other potential charities and things to make up the difference, essentially. And just for the storage allowance, one last important thing. For storage allowances, DSS is required to pay any late fees. So if there is a mistake on a client's storage is not paid right away, and you're trying to get that resolved with DSS, indicate to them not to pay themselves, because if they pay themselves, DSS will not reimburse them the money. So as long as you can get DSS to resolve the issue, your client won't be on the hook for any late fees or anything like that. But if they pay out of pocket because they're nervous their things will be auctioned, that money will never come back. That money will not be reimbursed by social services. Next slide, please. And finally, so what happens if you apply for all these programs and you're denied? Well, the first thing, and this is always the first thing, you always make sure a client knows that if they are denied emergency assistance, they get a same-day denial. Why is that important? It's important because you're going to want to request an expedited fair hearing right away. You have 60 days to request a fair hearing from the day of the denial. But of course, if a person's homeless, you probably don't want to wait 60 days. And it's important to have the denial notice with you when you request the hearing, because number one, it will likely have their case number, which will make things simpler, and you'll know the reason they were denied. An issue we have had in the past is clients will not be given a denial notice. We will request the hearing because it is an immediate issue, only to then find out either the reason the client understood or the reason they were told that they were denied does not match what was on the paperwork. And of course, you don't want to just request a fair hearing and wait, because that will take, somewhere between about 2 weeks on average, I'd say at this point, for expedited emergency hearings. You'll also want to advocate with, the center manager or the supervisor or whoever made the decision to deny your client, or whoever their boss is. So we have those numbers for the commissioner's response units for Suffolk and Nassau County on the slide. Next page, please. All right, so how do you request a fair hearing? There's a few ways to do it. You can do it online, you can call, you can mail, you can fax. Generally for fair hearings, I prefer to request it online or send a fax, but if it is a situation where the client is homeless and they need an emergency fair hearing, always call by phone, because in my experience, that is the only way to make sure that OTD understands clearly that you are requesting an expedited fair hearing and that it needs to be processed more quickly. I've also had 1 or 2 times where an expedited fair hearing, I was told what the date would be right on the phone, which obviously will not happen if you, send a fax or mail it out. Next slide, please. And then from here's just some other resources, the Coalition for the Homeless. If the client's a veteran, you could call the Department of Veterans Affairs. And then in Nassau County, we have phone numbers for Family and Children's Association and the Salvation Army. And I believe on the next slide, we have some more resources for Suffolk County. Yeah. Yeah, so then next slide, please. And that's it. I mean, thank you all very much. I don't know how to close it out.
Thank you, John and Jacob. So if anyone has questions, I know we already have a bunch of questions, which is awesome. So we will go through them, but if you have any questions right now, please put them in the chat. We will try to address them. before the end of our time slot. If we don't get to them, then we will try to reach out to you, or you can email us, okay? So everyone should have my email. So, Jacob and John. So let's get to the first question here. Let's go up, see here. So Cheryl made a comment that Suffolk DSS centers close the doors at 3 p.m. I know both of you aren't in Suffolk. You're in Nassau County. Do you ever have that experience in Nassau County?
I'm wondering if she means they close the doors at, like they're officially closed, or they don't let anyone else in at 3 o'clock.
Yeah, Cheryl, would you mind clarifying that? Just so we're all on the same page. If you're still on.
Can you hear me?
Okay. Yes, hi Cheryl.
Hi, sorry. If you are already inside, then, you may still be serviced, but the doors lock at 3.
Okay,
Okay.
okay, yeah, okay.
Yeah.
Thank you for that
Thanks.
clarification.
Sure.
Yeah, I mean, that's why we recommend people get the DSS before noon, because it's a long day. It's a long day anyway, whether you're a homeless applicant or if you're going there for other reasons. So the earlier you can get there, the more likely you'll be able to get some sort of answer before the end of the day.
Okay, great. Let's see here. Someone wrote, I've had folks share that no one answers the after hours DSS number. I know these aren't questions, but it'd be good to address them if you've ever heard that as well.
I have heard from clients that they have not been able to get a hold of someone, or they leave messages and don't hear back for quite some time. So I don't know if Jacob has any more direct experience on that, but it's been something I've heard, that they just have to leave messages, and usually you're not able to get a hold of someone.
Yeah, I've had a pretty similar experience to John there, where it's clients will leave messages, wait, and take them a long time to get through to somebody.
So then, hi, it's Deb Bernardino, school social worker. So what should we say to folks who have that experience and they need shelter?
I mean, that's why I think it's really important to go in person, to DSS if at all possible. That way, at least you can get seen that day, to get an answer. If it, I think also reaching out to nonprofit organizations that might have places for homeless individuals to stay at, having those connections with those organizations, at least like a temporary uh, night, so that they can then go to DSS the next day and then be seen and get an actual answer would be, the best advice I can give. And then obviously potentially, calling the commissioner's office to complain about that if it's such a pattern where clients are not getting calls at all. Sorry, Heather, I think you're muted. Well, let me see if I can go through the next
I'm sorry,
question.
John,
Oh.
We had some
We had some
technical
technical
difficulties.
Okay.
Hello. Obviously, I am not Sharon. I am Hannah. I am also in Legal Support Center for Advocates. Sharon has to go, so I'm taking over. So the next question is from Wally, and he says, "What happens if someone calls the after hours line and they are told that there is no place available, especially now in the cold weather?"
So there should be warming centers. I know in Nassau County we have a list of centers that are available. And I can share that flyer that I have for Nassau County. I don't, because I only practice in Nassau, I don't know the locations for them in Suffolk, but we can get that information and
Wow,
share it with everyone.
Oh, okay, okay. And then the next question is from Erica. And she is asking if undocumented persons are eligible for DSS homeless services.
So our organization primarily, we're only able to assist individuals that have some sort of permanent residency or status so we don't have, we don't represent clients that are undocumented, so I don't know the answer to that. I know Cheryl is much more of an advocate on that front. Maybe Cheryl can explain how that works.
sure, thanks. Yeah, I'm Cheryl Keshner from the Empire Justice Center. And I mean, it's our position that everybody should be housed. There's certainly during the cold weather, DSS has an obligation to house everybody, okay, or to connect them with someone who will house them. Um, you know, it was stated before that they have to do an evaluation for protective or preventive services before denying or discontinuing housing. And preventive or protective can be provided to someone regardless of immigration status. So, you know, it's our position that DSS should be doing that and should be housing everyone. As far as domestic violence, they do have to house everybody regardless of immigration status. So that's something that several of us here are working on together to try to get them to enact a more humane housing policy. But definitely during this type of weather, everyone must be housed. And, you know, we're trying to see about changing that throughout the year. Thanks.
Thank you.
Thank you, Cheryl.
Sure.
The next question is from Tom, and he's asking, how much time generally passes before the sheriff's department delivers a 14-day eviction notice form? And basically, how long can someone go without paying their rent after they delivered the form? I think this
Okay,
question
so
kind of
yeah,
implied.
so the 14-day sheriff notice is at the end of the eviction summary proceeding process. And so you've already gone to court, you've either worked out a settlement and not been able to comply with it, or agreed to vacate and didn't leave by that date, or had a trial or something that the judge said, this is your last day. And so the 14-day notice from the sheriff's office happens after all that's happened. And it's 14 days. It counts weekends, it counts holidays. It's the 14 days after the issuance of the notice. Anytime after that 14 days has expired, the sheriff can evict. So it could be the next day, it could be a few days after that, or a week later. We're entering a time period, typically, at least in Nassau County. I can't speak for Suffolk because I'm not in there and practice there, but generally the sheriff's office in Nassau, and I think it's the same in Suffolk, will hold off on evictions at the end of the year. So there is somewhat of a delay in the eviction, but typically when a client defaults on a stipulation, it roughly can take about a month for the sheriff to serve them with a 14-day notice. So, you know, there is a lot of lag. So typically there's some lag between when they have to, when they terminate, when they've defaulted on the stip or been ordered to vacate by the judge, that there might be a time period where they can still kind of get their things in order. And actually, Hannah, I think we actually may have skipped a question by Ryan, who asked, how long can an individual or family stay at an emergency housing facility? And that kind of depends on, you know, DSS will routinely have them come back for interviews and recertifications. And it depends also on if they're placed at a hotel, that they'll have to come back to DSS to get additional funds. So there's no time limit that I'm aware of on an individual staying at a location. I mean, not a location, but being housed by DSS. Now, typically, a lot of the shelters or the hotels will require that an individual will have to leave before 30 days, because once they're there for 30 days or more than 30 days, they technically could be considered a tenant. And now the hotel has to actually, to get them out, will have to actually start an eviction proceeding, a summary proceeding typically, to get them out. So a lot of the hotels will require, ask individuals that are staying longer than 30 days to vacate before that was 30 days. And so they may have to check out for one night and then check right back in. But as far as just DSS purposes, if someone's eligible for emergency housing, I'm not aware of any time limit on that, other than like the specific location. Specifically, like a hotel may say you have to leave but before the 30-day mark.
I'm sorry, John. This is Tom. I'm sorry to chime in. I had asked the earlier question about the time frame for eviction. The question was really how long does it typically take someone to get served that 14? Is it a month? Not after the notice was delivered, but
Oh, okay.
how long can someone stay in a rented apartment? Generally before they're kicked out and not paying the bills. Is it 5 months, 6 months? I guess everything
Yeah,
depends on the
that
situation, but in general.
that all depends on the situation. But if you're talking about from the date that they default on a stipulation, or when the judge's order was for them to vacate by a certain date.
No, prior to that. I'm sorry.
You're talking about
I
the whole
just stop,
process. Oh,
yeah,
well,
if I just stop paying my rent,
okay. You're
is it
talking about from
6
day
months?
one. You're
Yes,
talking
I'm
about from day
sorry.
one. Okay. Then that will very much depend on how fast the landlord is to start the proceeding, to give the termination notices or rent demand notices. Then the court's calendar and schedule. So I mean, generally it could be, as few as a few months if they're very fast with it, 3-4 months maybe, but it could be much longer. I have non-payments that have been going on for a year or more, or so. So it all kind of depends.
Marina called the front.
Sorry about that. So yeah, from the day they stop paying to when they're actually evicted, that's a wide range. Again, there's a lot of factors that go into that. So it's hard to give you a definite answer.
I appreciate your time. Thank you.
Sure.
Sorry for the confusion. The next question, is from Ida, and she's asking, I think she's asking something about like the school placement for kids. Like where the kids go to school will be a factor in determining placement for emergency housing.
Maybe Jacob might be able to chime in, but I'm not aware of DSS having a factor for that. I know that children that are in school can be bused to their previous school wherever they're located under the McKinney-Vento Act. So even if a family is displaced, there is bus services so they can go back to their original school district until they find more permanent housing. But I'm not sure if Jacob is aware of anything from his own experience with his own cases of a fact of like if DSS has to weigh that when they place.
To my knowledge, there is no regulation or statute that would require them to consider that factor. But I did have a case a few months ago where there was two pretty equally viable placements the client could go to, and one was closer to their child's school, and they placed them there.
Oh, okay. Thank you, Jacob. The next question is from, I'm so sorry if I get your name, if I pronounce your name wrong, Pilar.
Pilar.
She's asking, as housing advocates, how can we help a client when DSS does not do the proper assessment?
Jacob, you want to take that?
Sure. Well, I mean, I suppose it depends on the type of assessment. If the issue is that an assessment wasn't done properly at application, you could request a hearing and have them process the application, or if you could go down with your client as an advocate and make sure they process the application. If it's a matter of an assessment not being done before a case is terminated or discontinued, then you would request a fair hearing and ask that the case be reinstated until such assessment is done. You can request a hearing when these assessments that are required by regulation or statute or ADM aren't done. It becomes sort of a matter of what's the most practical thing to do to get your client into housing, depending on the context.
Okay, okay, thank you very much. The next question is from Pamela, and it's a bit of a long one, so if I do stumble on my words, I apologize in advance. Hi, library social worker here. We have clients come in at night and tell us that they are homeless and do not have a place to sleep for the night. Can you walk us through the process of what the client should expect? If it's after hours and they call the Nassau County after hours hotline, what information should they leave on the voicemail, and when should they expect a call back? And then there's like a space, and then another question that she had is, would clients seeking emergency shelter when calling the after hours number have to already have the LD, I'm sorry, I'm a little, LDSS 2921 application filled out?
So for the application, they don't have to have that filled out when they call the after hours number, or they don't have to have that already filled out beforehand. They'll just, if they call the after hours number, they should leave a message with their location, with the circumstances of what happened, the best number to reach them, and alternative numbers if that first number is not available or may not work because the battery may die. I don't know, Jacob, if you have any other thoughts on what maybe would be best to leave on a message. And again, they should receive a call before within that night, but we have heard that callers don't, and that also kind of depends on the demand that night. Colder nights like tonight or the last few days, obviously there's a lot more demand. And that's why, if clients can get to the warming centers in their county or to a nonprofit that has a bed location, that would, be ideal, at least then to get them ready and situated to go to DSS the next day and try to get assistance there.
Okay, thank you very much. The next question is from Emily, and she is asking, what are the allowances for safety net assistance?
So the safety net assistance is under is part of public assistance, the cash assistance. So I mean, it depends on the standard of need for the family. So it kind of depends on the family size, and each county has different allowance, or the standard need allowances are different. So I can't give an exact answer on that, but we can probably share the standard need chart for both Nassau and Suffolk County, which lists, all the information there that might answer your question on that one. And
Okay.
that hasn't been updated since 2012, as far as I know.
Okay. And then the next question is from Wally, and he's asking, are there written policies DSS can share with CBOs?
Can you explain what you mean by CBOs? I'm not familiar with that term.
I
Is
also
Wally
don't
still
know
here?
that.
Community-based organizations.
Community-based organizations? Oh,
Yeah.
okay. So So written policies that DSS has to, OTDA, OTDA, their website, has a directory for all the guidance and directives that DSS has to follow. And so you can look those up by word or by the directive number. There's a number of them, so those are all posted on OTDA's website. And we can provide you with a link to where you can find that.
And just for everyone's knowledge, the search function on OTDA's website can be a little messy. If they will release ADMs, per year, they'll be categorized by the year they were issued. And when you're using their website and searching for a word, it will only search within that year. So you may be looking for something, search, think it's not there, and it's because it was issued in 2022 as opposed to 2024.
Okay, thank you. The next question is from Lizetti, and she's asking if we can email the resources. If you mean the resources as in this presentation, it should be emailed to you at the end of this presentation. If you didn't already receive it. And if you do have any additional questions, you can always email Sharon Campo, who was in the beginning, at scampo@legalservicesli.org, or you can email Jacob or John for the questions. Okay. Let's see. Is there any other questions that we can?
There's one that I do want to get to because I think it's talks about for tenants that have mental illnesses but aren't under care of doctors, how do we document need for a reasonable accommodation? So Jacob, you can chime in as well if you have other suggestions, but I think it's would be important is if they don't have any documentation at that point to try and get them linked up to a doctor's office or a hospital that can do an assessment and get some basic level of an evaluation for them. DSS does have their internal doctors, but you do want to have them be evaluated, especially if you really do believe they have a mental, any disability. You want to make sure that they're seen and get that treated, and figure out a game plan for how to go about that. But so you first try and link them up as soon as possible. The next would be to see if there's if you can get the case comments from DSS, if they have a long history of being at working with DSS, to see if there are any assessments or comments or reports that suggest that they've previously given them an accommodation before, that may be able to help you get in the door and allow them to issue another accommodation in the future. If they've previously done that evaluation and it's not something that may have changed or would have likely have changed from that time period.
Do folks have access? So do people, as advocates, maybe with HIPAA, we're not allowed to ask for those things, but can a person ask their DSS worker for assessments and reports, and how do they go about that?
So as an advocate, there are contacts at DSS that we use that will allow us to get us the case comments, going back as far as we potentially need. So as an advocate, I think you'd be able to reach out to DSS's fair hearing unit to, I believe that's how it is in Nassau. I'm not sure how it is in Suffolk, but there should be contacts there or FOIL reps that would be able to help you get those case comments, as long as you have a release. And at least in Nassau County, they accept our own internal release. I don't know if Suffolk has a specific release that they require, but we have a pretty good ability to get those documents from Nassau County. And that can sometimes, show. In one situation, we had a fair hearing where a client was unrepresented, and we were then able to get the fair hearing restored and reversed, the decision reversed, because it was based on whether she was able to really comply with the requirements that DSS was asking for, and they had they had previous knowledge that she wouldn't have been able to, and so she needed accommodation. So that's a situation where we were able to use their own notes against them and help a client.
Alrighty, it looks like we are at time. So apologies that we couldn't get to all of your questions, but I wanted to thank everyone here for coming. It was very nice having you all. If you have any other questions, as I said earlier, you can email my supervisor Sharon at scampo at legalservicesli.org. I believe Jacob's information and John's information are also in the PowerPoint presentation, which will be emailed to you at the end of the presentation. And then if you can always call the Legal Support Center for Advocates. My extension is free if you ever want to talk to Hannah. I'm rambling a lot, but thank you very much, everybody. Have a great weekend.
Thank you, everyone.
Thank you.